Juju68 is having his Blair Witch Project moment here. He's scared out of his mind over things he doesn't understand. And I will help you understand 39.13.605. But first I want to say that if you can't cite the case that held it, perhaps you shouldn't say the Supreme Court held it. The Supreme Court has not held that there is no right to privacy or no expectation of privacy in public. The closest thing that they would have said about that is that in a Fourth Amendment sense, if an officer, a police officer can see it, it's not a search. If the police officer is where the police officer is legally allowed to be, like in public, and he can see it from where he's legally allowed to be in public, then it's probably not a search. You have a expectation of privacy in public. You don't expect the police to come up and just reach into your pockets to see what's in there. You have a reasonable expectation of privacy in public. You don't expect people to film up your skirt, down your blouse, etc. Use cameras that can see through your clothes. You have a reasonable expectation of privacy in public. So with that said, 39.13.605, we're going to take a little gander at it. So part A is the actual meat and bones of it. This is what it's illegal to do. B, C, D, E, and F, they just kind of, B gives some description or some definitions. C says what happens to the photographs when they're done. D is sentencing. E says that that this won't preclude someone from charging under a different criminal section. And E says that they can order, the court can just add other things to sentencing. So we're looking today, because A is the meat and bones. We're going to look at A and B, actually, because those are, well, we're going to look at A, B, and E. Yeah, A, B, and E. Because those are the important parts, at least for us today. A says, it is an offense for a person to knowingly, remember knowingly is an intent state, mens rea state, photograph or cause to be photographed an individual when the individual has a reasonable expectation of privacy without the prior effective consent of the individual, or in the case of a minor, without the prior effective consent of the minor's parent or guardian, if the photograph. So it's an offense for a person to knowingly photograph an individual when the individual has a reasonable expectation of privacy if the photograph, and this is joined by an and, would offend or embarrass an ordinary person if such person appeared in the photograph and was taken for the purpose of sexual arousal or gratification of the defendant. So you need both of those. So, well, let's see, if you're in public, could someone take a picture of you that would offend or embarrass you if you appeared in that photograph? Yeah. I mean, like, if you're right in the middle of a yawn, or, you know, if you slipped and fell and they took a picture of you, like when you're on the ground, you know, looking confused and hurt, that'd be embarrassing. But they also have to take it for the purpose of sexual arousal or gratification. And you're like, oh, well, well, you know, maybe they just have a real fetish for yawning people. So maybe, but then we go back up in here and we say, oh, reasonable expectation of privacy. Do I have a reasonable expectation of privacy when I'm yawning? Well, maybe it'll go into the definitions. Is used in this section, unless the context otherwise requires. A photograph means any photograph or photographic reproduction, still or moving, or any videotape or live television transmission of any individual. So basically anything that produces a picture or moving picture is going to suffice. That doesn't really help us. Let's look at 2. As used in this section, an individual has a reasonable expectation of privacy. Whoa, this is what we want. So we want to figure out when we have a reasonable expectation of privacy, regardless of the location where a photograph is taken. Uh-oh. So, if A, the person is, or the photograph is taken in a manner that would offend or embarrass a reasonable person, And, see there's an and there, the photograph depicts areas of the individual's body, clothed or unclothed, that would not be visible to ordinary observation, but for the offensive or embarrassing manner of photography. So, how could you possibly be in violation of the statute? Let's think about it. If you have one of those cameras, they were pretty popular back in like the 2000s, where they had an infrared. You could turn on the infrared for night vision at the same time it was recording in the visible spectrum, and it would kind of sort of ish allow you to see through people's clothes. So that would certainly suffice for this. If you were trying to film up a lady's skirt or down her blouse, that would do, or I guess, you know, this is California, so up a guy's skirt would also work, I guess. Maybe down a guy's blouse. I don't know. But it could theoretically, oh, this is Tennessee. I don't know. Do they do that in Tennessee? I don't know. So basically, if you're getting past their clothes, or if you are in a place where you're allowed to be in photographing, but somehow you're able to film into an area where a person has an expectation of privacy, like if you're able to take a picture through like a hole in the wall, a la Porky's, or, you know, with a telephoto lens or something like that. If you're able to film in a place where a person has a reasonable expectation of privacy, and it's got to show areas of the individual's body, clothed or unclothed, that would not be visible to ordinary observation, but for the offensive or embarrassing manner of photography. So like if somebody's like up on a hill far away from you and you're using a telephoto lens to be able to see through their window because they're so far away, and you're able to take pictures of them in a state of undress, then ta-da. So this isn't about taking a picture of a building from a sidewalk. This isn't about filming a police officer. Because if you film a police officer, would that offend or embarrass an ordinary person? Probably not. Would it be taken for your sexual arousal or gratification? Probably not, theoretically, I guess. Some women like a man in uniform. I don't know. But also, would the officer have a reasonable expectation of privacy? And so the photograph would have to be taken in a manner that would offend a reasonable person, and probably not. And it would have to depict areas of the officer's body, clothed or unclothed, that would not be visible to ordinary observation, but for the offensive or embarrassing manner of photography. So you see, this won't apply to your ordinary auditor interaction. And just to kind of pound it home, nothing in this section shall preclude the state from electing to prosecute conduct in violation of this section under any other applicable section, including Chapter 17, Parts 9 and 10 of this title. What are Chapter 17, Parts 9 and 10 of this title? Well, ya boy has the answer. Chapter 17, Part 9 is obscenity, and Chapter 17, Part 10 is sexual exploitation of children. Obscenity is not protected by the First Amendment. Sexual exploitation of children, a la child porn, is not protected by the First Amendment. Invasion of privacy is not protected by the First Amendment. So I hope you can see that this is completely constitutional, at least as it appears. Who knows if they try to implement it in some unconstitutional way, but it appears to be completely constitutional. So just relax. Juju 68, just relax. It's okay. Suck the snot back in. There is no Blair Witch. Thanks for watching. Have a great day.